24th day of May 2021 by the second petitioner.
Yes.
We have two other witness statements.
Yes.
Sworn by one Jacob Ongundo.
By Jacob?
Jacob Ongundo.
May I have the dates, please?
My Lord, we have a list of witnesses dated the 30th day of October 2025 and two witness statements attached there.
Let me just get to it. '30th October 2025?
Yes, my Lord.
Yes.
Yes, my Lord, that list of witnesses lists the witnesses that we will also be calling.
Yes.
To lend support to the petition, my Lord.
A supplementary list of witnesses, both dated 30th October 2025. You ready to proceed?
Indeed, my Lord, thank you.
Mr. Maro?
Your Lordship, on behalf of the first and second respondent,
Yes.
I am equally ready to proceed. However, Your Lordship, we have the application before you under urgency.
An application dated?
The application, Your Lordship, is dated 13th January 2026.
Yes.
NACADA, which is the regulator on the question of drug abuse, seeks to be enjoined in the proceedings. And in my assessment, Your Lordship, I believe NACADA is a key party in the proceedings before this court. I'm in support of the application, Your Lordship, but we need to get directions from the court how to proceed now that the application before this court for determination. I am not opposed to them being enjoined, Your Lordship. I will allow Ms. Daka to address court on that question, since she's the mover. Thank you, Lordship.
Ms. Gako?
Your Lordship, we were made aware of this matter later early this year, and that is why we have filed this application late. We would like to seek the indulgence of the court to allow us to file responses with regards to this matter as the lead agency to give our input so that the court can make sound decision, Your Lordship.
Thank you. Mr. Omboy?
My Lord, indeed it falls within the purview and the powers of the court to allow or disallow an application for joinder. Be that as it is, my Lord, we will be pleased if we were served with the application. My Lord, I know that it is in the interest of justice that also NACADA gets to be heard.
Yes.
Granted, my Lord, we know that it is also going to affect the timelines that the court gave us. My Lord, there are certain concerns coming from my clients that we will wish to raise so that while the court is considering granting my sister time to put in her response,
Yes.
my Lord, there has been concerns from my client that on the number of occasions we have come before this honorable court, their images have been out in the public, and as a result they have been an easy target by police officers.
Yes.
Apologies on his behalf, you will switch it off. Your Honor, my Lord, there has been constant pestering and unwarranted searches in the persons and in the homes of my clients, whose images have been appearing on various media stations.
Yes.
My lord, now that it appears that our target is shifting because of the involvement of my colleague from NACADA, we'll be praying, my lord, if it pleases the Honorable Court, that the court can be pleased at least to give a temporal relief or measure for my clients who are members of the first respondent, to at the very least operate without the constant disturbance and warranted searches from police officers because of the stereotype that even while they do not possess the cannabis,
yes,
my lord, they are under constant pestering from police officers, and this, in a sense, and in their belief, is meant to influence the life of the petition that lies before the Honorable Court.
yes.
So, my lord, even while you grant or you give directions as the court will please fit and convenient in the circumstance,
Yes.
we'll be praying, my lord, that you give certain directions meant to protect my clients from constant harassment from police officers. Thank you, my lord.
Before we go to Mr. Maro, on that point, Council Omboy, you recall your application dated 17th May 2021, the notice of motion?
Indeed, my lord.
May I read ground D of that application, that the police continue to harass, intimidate, arrest, and cause the prosecution, persecution, and even imprison first responded for privately, and it goes on and on and on.
Indeed, my lord.
Consider that as I hear from Mr. Maro. Mr. Maro, you are rising?
Yes, Your Lordship, in response to the application made by my colleague, Mr. Omboy, regarding the order. Your Lordship, I'm aware of it.
Yes.
Your Lordship, but there is no evidence that has been submitted before this court supporting the allegation raised by my colleague that any of his client has since been arrested and detained
Yes.
on the question of marijuana, Your Lordship. Your Lordship, that is the order being sought in my view, Your Lordship, seems to be a final order in nature.
Yes.
If you look at the amended petition, that is among the key orders that have been sought. So, Your Lordship, my plea to this court is that, Your Lordship, bearing in mind the involvement of NACADA, Your Lordship, and NACADA being a key party in these proceedings, I would request this court to give us short timelines for compliance, Your Lordship. We can come back next week. All NACADA needs to do is to file a reply to the petition, which I believe, Your Lordship, will not take more than 3 days. And then with the indulgence of this court, you can squeeze us in, Your Lordship, sometime next week or even the first week of February, so that we can hear this matter on merit, Your Lordship, without Your Lordship issuing that order, which I believe is an order, Your Lordship, that can be given on merit, Your Lordship, that both parties must be heard. And I get instructions from my client if indeed that issue has been a torn issue for Mr. Omboy's clients, Your Lordship.
We have a judgment date of 12th of March.
We can maintain that date, Your
We
Lordship.
have a date for highlighting of 10th of February. Nema, I see the date. Mr. Omboy, are you opposed to the joint of NACADA?
No, my lord. So that we expedite on the matter, they can just join in.
Ms. Gakwa, how much time for responses?
Your Lordship, I think 7 days would be reasonable enough.
So what we are proposing is we take out today's hearing and tomorrow's hearing to allow NACADA to catch up. We are proposing substituted dates of 30th of January, that is a Friday, and then Wednesday, 4th of February. Mr. Wambui?
It's convenient.
Okay, so that is the dates. Now we have a date for highlighting. It will not be possible for us to maintain that date, but let's try and run it through and see whether we could retain the date for judgment. So further, the interested party shall file and serve responses to the petition and shall do so by close of business Tuesday, 20th January 2026. Ms. Gakwa, will you be calling witnesses?
Your Lordship, I think I need to confirm that.
Okay. Rejoinder, if need be, to be filed and served by close of business 27th January 2026 by the first and second petitioners and by the third petitioner if the interested party wishes to call a witness or witnesses. They shall be limited to the deponent or deponents of the replying affidavit filed and served by close of business 20th January 2026. Today's and tomorrow's hearings viva voce are taken out and substituted with 2 hearing dates of Friday, 30th January 2026 at 10 a.m. hybrid and 4th of February 2026 at 11 a.m. hybrid. So we'll come to open court, but we'll have the hybrid available. So that is hearing dates. Realistically, we then cannot highlight. I would want us to already secure those amended timelines. We had fixed the 10th of February. That will not be possible. You will not have written submissions by that date. Mr. Wambui, after the hearing of the 4th, how much time would you need to put in comprehensive submissions?
I'm around about 7 days. We've been working on our submissions throughout the December holiday.
So that would take you, so 4th is a Wednesday. That would take you to Thursday, 12th of February. Mr. Marble?
Your Lordship, I'll take 3 days after service.
3 days after service would take you to Tuesday 17th. Ms. Gakwa, you can also have that same time because you'd be opposed. Council Omboy, after that, rejoinder, rebuttal, written submissions.
2 days, my lord. If necessary.
I suspect it will be necessary, so let me give you close of business 20th February 2026. Now, days for highlighting are at a premium. We had said judgment 12th of March. Let me sidebar again with my boss. The 24th of February for highlighting. Ms. Gakwa, Mr. Maro?
Your Lordship, for me the date is contingent. I equally take the same amount of time.
Okay, so we will, Ms. Gakwa? It's convenient? Okay. So 24th of February, and then the judgment date will move slightly. We had given it as 12th of March. We'll push it back by a week, so it will go to 19th of March. Let me then formalize that. So we had left it at 4th of February 2026 at 11 a.m. hybrid. At the conclusion of which parties shall file and exchange written submissions. The petitioners shall do so by close of business 12th February 2026. The respondents and the interested party shall do so by close of business 17th February 2026, and the petitioners shall have leave to file and serve rebuttal written submissions by close of business 20th February 2026. Highlighting of written submissions shall be on 24th of February 2026. With the highlighting date of 10th February 2026 being vacated accordingly. Similarly, the previously fixed judgment date of 12th March 2026 is vacated, substituted with 19th March 2026. Nema, we'll do it in open court. Can we say noon?
Yes.
So 19th of March 2026 at 2 p.m. At 2 p.m. in open court with hybrid support. So we've vacated today and tomorrow. Now this is a 2021 matter. That is why you're seeing I have endeavored that it has to be fully heard and determined within Q1 of this year. there will be no further adjournments. There will be no variations of this date. Whatever is the state, I will deliver a judgment in that regard on the 19th of March. Is that well understood? Now, Councillor Wamboi, this, you have two options. You can either file a formal application, because I'd want to see the affidavits. I'd want to see what is being alleged. I will then look at it in chambers. But I would also perhaps request that, given that the 19th of March is just around the corner, perhaps we can hold off on interlocutories unless it is very, very pressing, because we may end up in a situation where I am unable. And you're aware the Court of Appeal has been very clear that you have to determine all interlocutory applications before you can render a judgment. Yes, so just seek further instructions. If you file a written application, I will look at it in chambers, do what is necessary before inter partes.
Thank you, my lord. I'll advise my clients accordingly.
Yes. Now, Mr. Marwa, that is also something you can advise your clients, that there is a pending petition, and perhaps we can keep the ordinary.
Your Lordship, I'm willing to do so. I've just been ambushed by the submissions of my friend Mboi.
It's hardly an ambush, given that it was there in the application dated 17th of May, but I hear what you're saying. Ms. Gakwa, anything else?